Good morning. We're back in session. This is the second case. Before I announce it, actually, just because some folks weren't here when I did my initial announcements, I'm Dan Traver. I'm the Chief Judge of the Court. I'll be presiding over today's OA. To my right, your left is the Honorable Carrie Ann Wozniak. To my left, your right is the Honorable Joshua Mize. We're being streamed live on YouTube. If you would be so kind as to silence your cell phones if you've not done so already. This is case number 24-1357, Jimmy Rushing Jr. versus Sylvia Rushing. Are you Mr. Mockler?
I am, Your Honor.
Are you going to be arguing this morning?
I am, Your Honor.
You may proceed whenever you're ready.
May it please the court. When you serve in the military and you're on a retirement, on a pension plan, two things typically happen over time. Absent wrongdoing or something unusual, military service members get annual pay raises through a COLA. They also get time and grade, time and service pay raises, and they get pay raises as they're promoted. That is the norm. And that is the case in this case. In addition to your pay going up, as you serve more time in service, your percentage share of your base pay increases. So typically at 20 years, you're entitled to 50%. And each year thereafter, complete full year, you obtain another 2.5% share of your retirement. So at 21 years, you're at 52.5. At 22 years, you're at 55%. So your pay is going up and your share of that base pay is also going up. Okay. Master Sergeant Jimmy Rushing filed for petition for dissolution. What was in April of 2013. He retired in September of 2018, wherein he added 6 additional years, full years of military service. Now that's a period of only 5 years and some odd months, but he crossed 6 thresholds during that time period. So he went from being an E7 with 18 years of service to retiring with 24 years of service. The supplemental final judgment in this case violates not every rule in the Book of Equitable Distribution, but almost every rule. And it violates them blatantly and inexplicably. So one of the black letter rules of equitable distribution is you can't modify equitable distribution. That's every case that's ever been heard. No case says otherwise. No case in the history of Florida law says, well, you can modify equitable distribution if you feel like it, or if somebody's pays late or does something. It's non-modifiable. Black letter law. What does this case do? Well, it modifies equitable distribution. Another, in the more niche area of pension division, this case violates another black letter rule of law for equitable distribution, which is that a court may not award post-divorce accruals of benefits, such as time and service, time and grade, pay raises, raises in rank. Somebody could get divorced as a captain and retire as a colonel. The former wife wasn't married to the colonel. She was married to a captain, or vice versa. The former husband wasn't married to a colonel. He was married to a captain, whatever the case may be.
Is the parties' marital settlement agreement as it relates to your client's military pension unambiguous?
It is absolutely unambiguous. And here's
Perhaps
what
we should talk about: the plain language of the agreement as opposed to the other considerations that you've been discussing so far.
Okay, so the perceived ambiguity is between 2 different clauses. One saying that they will be divided pursuant to 28 USC 1408, which is the Service Member Civil Relief Act, which simply says that you're,
I didn't understand your colleague to be arguing that there was an ambiguity in front of the trial court. I understood you both to be arguing that it was unambiguous. Is that fair?
my view is that it is unambiguous what, particularly concerning that clause and also concerning, our position is it's not ambiguous because what it tells us, right? And the former wife is going under substantial change of circumstances theory. She literally pled in her pleadings that there was a substantial change of circumstances, and she expressly asked for to award the retirement as of his date of retirement, not as the date of the divorce, which was 5+ years earlier.
If we see this your way, do you believe that there is authority for us to reverse and remand under the existing petition?
Yes.
Okay, what does that look like?
The issue is that the remand should make clear that the court is not permitted by discretion for any of the reasons that she found to read out of the final judgment that the retirement pay shall be calculated at the salary, right? So we need a salary and rate attributable to the former husband's rank at 18 years, comma, which is the rank in years that the husband had attained at the time of filing of the petition for dissolution of marriage. So we had no consideration of the salary, no consideration of the rank at 13 years. The court awarded, 2013 at 18 years. There was no consideration of that. What the court awarded was at 24 years of full retirement at his actual retirement date in September of 2018.
Is the directive then that it would include a revised military pay order that includes those factors?
It necessarily must, yes, and it must include and account for the salary and a rate attributable at the rank of E7 at 18 years, which is.
So it would be the percentage that's contemplated by the formula, which you guys agree on. It would be.
The percentage is correct.
Can you just let me finish? Just
Yes,
to make sure that I have this correct. The hypothetical retirement date, which would have been April 11th of 2013.
Right,
Husband's rank when the parties divorced, which was E7.
correct,
The former husband's years of service when the parties divorced, which was 18.
correct,
And former husband's retired base pay, which is 3822.51.
also correct.
Is there anything that's missing there?
Nothing's missing from that recitation.
Okay.
What would have been in a commonplace in a family law order is to include the 3822 in the marital settlement agreement. But the case law authorizes the court to do math to give effect to the terms and words that are in the parties' agreement. So in this case, it says the correct percentage of military retired pay to be paid to the wife using the formula set forth above, right? And, that's an and based upon the husband's rank, years of service, and retired base pay set forth above. We did no calculation of the retired base pay. The trial court literally read that language out of the agreement, read the rank and years of service out of the agreement. The supplemental final judgment vitiated every important term of the agreement as it pertains to the husband's retired pay, except for it's a correct percentage. But what we're asking this court to correct is the percentage of what? The percentage of, I submit to the court, should be based upon the husband's ranks, years of service, and retired base pay. So you need a percentage of something. That's the 3822. That's the retired base pay set forth above. Okay. And how did we get there? Because there's a lot of fuss about using a high 3. But when everybody who retires in the military after, I think it's about 1980, is under a high 3. In fact, Master Sergeant Rushing retired at a high 3 in 2018. So it's always a high 3, but that high 3 is moving up over time as you increase your time in service, time and grade. So his high 3 in 2018 is a much different number than his high 3 should have been or was in his 2018 high 3 that he actually retired under is different from his April 2013 high 3, which we had an expert witness calculate and present to the court. So we're not asking for any type of windfall or strange calculation. We're asking the court to take the same high 3 retirement that actually occurred in 2018 and date it back 5+ years to April of that occurred in 2018 and dated back to 2013 when the divorce occurred, when the petition occurred. Other things, other factors that to address is that this was not a situation where we needed to file a motion for rehearing. This was a single, I'll call it a single issue trial, was dividing this military retired formula. And we argued ad nauseum throughout the entire trial, all of these points, and the court simply rejected them. They picked the former wife's argument over the former husband's, reading out everything we argued should have been considered and should have been in there. And that is not a case where the court, and conceptually, like when you have a mandatory motion for rehearing, that's because the court ruled on something it didn't have a chance to consider. Like, you didn't put in the proper facts, or you didn't check these boxes, or something that was never argued before the court. Here, these arguments were all made, all on the record, fully developed, and a motion for hearing wasn't mandatory here. I also thought it's important to basically to try to come up with legal sorcery to get this modification, right? To impermissibly modify equitable distribution and award the wife a post-judgment share of his retirement. Two other arguments were that, oh, well, you had an affirmative defense a couple of pleadings ago that was withdrawn and replaced by an amended answer by new counsel that took out that affirmative
Yeah,
defense.
but it's an unambiguous agreement. I don't know why that matters.
Agreed wholly. And the other one is that, oh, well, you didn't pay while we were during the dispute, so we get to modify and take a higher percentage then. That is not the remedy. The remedy is you order retroactive at the correct rate, not that you impose a punitive measure and modify equitable distribution. The case laws, every case that's ever considered, whether you can modify equitable distribution based on misconduct, says no, you may not. Every case in the history of Florida law that looks at the issue says no. So we're dealing with, there's actually a lot of clarity in this case. There's so much clarity that there's a nearly identical case called Lawrence. I believe Lawrence is out of the 5th DCA, used to be here, now it's not binding, but there's no case to the contrary. So I would, suggest it's at least highly instructive, if not binding. Well, not binding on this court, I'm sorry, it would have been binding on a trial court. But in any event, Lawrence teaches us that where you don't account for the post-judgment, post-divorce accruals of benefits, pay.
Counselor, you're telling us a lot about how military pensions work. And I get that, the settlement agreement here mapped pretty closely about how military pensions work in the absence of a settlement agreement. But it could have also not, right? If the settlement agreement had said, we split the pension 50-50 as of the time he retires, that'd be enforceable too.
I agree 100%.
Yeah, so I guess what I'm saying is, all the explanation you're giving us about how military pensions work, while, interesting, it seems to me to be completely irrelevant, right? It's just what the agreement says. It so happens that this agreement utilized language that was close to how military pensions work without an agreement, right? In the absence of an agreement. But that's just a coincidence. If they want to alter it, how military pensions normally work, they can. So is it relevant how military pensions normally work, or is it just solely relevant what this agreement says, and that's all we should think about?
I believe how it works is relevant in the following ways. I agree with the court as a basic principle. This is a contract. This is a contract interpretation case, and the court should apply and interpret what the parties agreed to. But when I discuss how do pensions work, it's because it's all tied into the language of the agreement, which is tied into how pensions work insofar as we have things like based upon the husband's rank, years of service, and this is the key word of all, retired base pay set forth above. The retired base pay, the relevant retired base pay is April 2013. That's what's contractually bound. That's unambiguous. And that's where the court needed to do some math and put a number in. We did the math. We submitted the math. We had substantial competent evidence that was based on the military pay charts. And they say, no, we get it at 2018 when he retired. That flies in the face of the agreement, the plain letter of the agreement, the plain language of the agreement, the words of the agreement, and basically almost in the entirety of the agreement, it flies in the face of what the parties intended, because like Lawrence, the parties intended to split it 50-50 as of the date of the divorce. That's the key. They intended to split it 50-50 as of the day of the divorce. And all these words that were read out are important. And as this court as well, where you're not allowed to read out the core language of the agreement, I'd like to reserve 5 minutes and 56 seconds.
Thank you. Mr. Pierce.
Thank you, Your Honor. May it please the court. The appellant stated that the final judgment violates every rule of equitable distribution. He said it was black letter law. Said that as far as the pension division, there should be no award of post-divorce rule. Judge Mize asked whether or not the parties could have drafted a contract that close to the military, but actually not the military. Of course they can. That's the Nix v. Nix case. Now, there was also a question whether or not there was an ambiguity. We both argued that it wasn't. We were both incorrect. The lack of clarity in this contract, where if we follow appellant's position, the tail wags the dog. Because if we're going to look at the words, it specifically states, effective on the first day of the first month following his retirement from active duty with the United States Air Force, and on the first day of each month thereafter, the husband shall pay or cause to be paid to the wife as a property right from the husband's United States Air Force retirement pay, an amount of his disposable retirement pay as defined in the Uniformed Services Former Spouses Protection Act. Those words have meaning. And if that is the case, that is what it should be divided in accordance with that. And there was a formula that was given.
Do you just stop there?
I'm sorry?
Do you just stop?
Absolutely not.
All right. So when you talk about the rest of that paragraph, specifically the wife's percentage share of the husband's disposable retirement pay shall be calculated at the salary and rank attributable to the husband's rank of E7 at 18 years, which is the rank in years that the husband had attained at the time of the filing of the petition for dissolution. How do we get to the trial courts and your chosen interpretation of that language without completely reading out that verbiage?
I was going to get to that.
Please.
There's the ambiguity. It's because of the percentage that's used in the first part, and then you look at the second part. The trial court realized that. The trial court even asked, don't you see an ambiguity? Both parties said no. Okay, but when the trial court brought it up, and
I mean, I'm inclined to agree with both of you guys that we can look at this particular provision of the marital settlement agreement and give faith to every word that's in it, as opposed to selectively reading some words out and other words not out.
I would have to disagree, and here's the reason why.
But you understand you're disagreeing with both your motions in limine and your position at trial.
Well, not,
You specifically said, and correct me if I'm wrong, we don't even need to hear from this military pay expert because this agreement is so unambiguous that we can just look at what it says and apply it.
based on a reservation of jurisdiction, that's correct. Okay, that's based on a reservation of jurisdiction. The reservation of jurisdiction was solely to send a percentage to DFAS. That's what that is based on. Now, as far as the language is concerned, although the court just stated, well, we can just go ahead and do it, actually we can't. Because if we look at 143 over AD as far as the active duty, that gave us the 28-point percentage. That's the fraction. That's the fraction that the appellant wants to apply in the retirement portion. The expert said that is the number. Well, if you actually follow the appellant's argument, it would actually mean that the appellee should receive 33.33% as opposed to the 24.83%. That's a 25.5% haircut that the appellee would take. No one signed up for that. That is why there is ambiguity there. When the expert is saying that the correct number denominator is 24.83%, but the calculation below shows that it is supposed to be 33 1/3. That's an ambiguity. And that's one that needed to be addressed at the trial. When the judge said, when the trial court stated that she saw an ambiguity, I mean, I think you can tell by the transcript, of course, my position was, uh-oh, she's right, there's an ambiguity. So from that point, of course, you have to look at the intent of the parties. And that is why we looked at the intent of the parties with parole evidence. Now, not only that,
Do you agree that we're in the exact same position as the trial court was as it relates to analyzing this contract?
that's what the case law states.
All right, so again, I guess I go back to the question that I asked for that statement in the marital settlement agreement about how the wife's percentage share of the husband's disposable retirement pay shall be calculated. How do we get to your interpretation of that contractual provision without eliminating that language entirely?
Well, here's what you have to look at. Here's what you have to look at. There are two, at least in my eyes, as I'm looking at it after, at the trial. These paragraphs cannot be read in complete harmony, just based on the language itself.
I guess I don't want to get you there yet. I just want to get an answer to my question about how you read it the way that you want to read it, and that the trial court read it without reading it out entirely.
There's an inconsistency there, as far as reading it out entirely. If you're looking at the husband's disposable retirement pay, I understand as far as the calculation, and it would appear that it is read out entirely. However, I do not believe that it is completely read out entirely. Because I think there's a conflict there, Your Honor. I think there's a conflict there.
You're
And-
saying those two parts of the paragraph are just an irreconcilable conflict and that they,
I believe so. I believe that they're, because of those numbers, especially if you look at the percentages and you look at the percentage of the first where it's 143 over the total amount of active duty. The total amount of active duty that was calculated was based on when he actually retired. And that's what the expert said was appropriate. Again, if you take that, which is what they want to do, and apply it to the second portion, the appellee takes a 25.5% haircut.
So then your take on it is that because of that haircut, and I'll set aside for a second that the parties agreed that it was 24.83% the trial, and that there was no dispute over that. So I'll set that aside for a second, because it seems like you're trying to bring that back in. You're saying that because it's potentially could be more for your client means that the remedy is to read out the language?
No, I'm not saying that at all. I'm saying that there's the ambiguity there which needed to be addressed via parole evidence.
you didn't just say there was an ambiguity. You said those two parts are totally and completely irreconcilable.
Well, yes, they are completely irreconcilable, but if you go through, as far as latent ambiguity, it can be read, if we look at the first part, we'll say, this is
When
not clear.
provisions are totally irreconcilable, and do you refer to that as an ambiguity? Is that how the case law works? Is that the next step in that logical process? Two provisions are on their own, each have a meaning, an ambiguous meaning, and those two meanings are totally and utterly irreconcilable. Do we then go to latent ambiguity? Is that the next step in how that works when you have two provisions that on their face are totally completely irreconcilable?
Is that?
Because that's what you said. You did,
What?
I asked you specifically, is it You said it's not just ambiguous. You said the two parts of that paragraph are totally irreconcilable.
Yes,
When you have two parts of a contract that are just totally and completely, utterly irreconcilable, do you normally then go into a latent ambiguity process, or is it something else?
if you have something like that, normally, depending upon when it's introduced, whether or not you're looking at clarification or a motion, I'm talking about at the time when it was drafted. But if you look at the way that it's drafted and you see two irreconcilable parts, I believe that, yes, you would have to look at it as ambiguous. But I understand what the court is saying as far as the latent ambiguity. It's when two things can be written, both parties are reading it, and it can be reasonably perceived in two different ways. I understand that, and this is irreconcilable. So.
The reservation of jurisdiction paragraph says that the calculation, there's a reservation of jurisdiction for the trial court to calculate the correct percentage of military or retired pay to be paid to the former wife. And that requires that the mathematical formula set forth above be used. It also has language in there that says it's based upon the former husband's rank, years of service, and retired base pay as set forth above. What does that set forth above mean if it doesn't mean 18 years in E7?
As set forth above, as far as the equation is concerned, it's 143 over AD times 0.5.
Right. So let me ask the question again. So it says that it needs to be calculated by the correct percentage of military retired pay to be paid to the former wife. And that is based upon the former husband's rank, years of service, and retired base pay as set forth above. So if I understand your answer correctly, you're basically saying that all that is the mathematical formula. That was your position at trial, correct?
Yes,
Okay. What do I do with that language that says based on the former husband's rank, years of service, and retired base pay set forth above?
in the first paragraph, you have to include all of that. You have to include it in the first, it is mentioned in particular in the second, but in the first section, you still have to consider all of that as far as the calculation, because the Uniform Services Former Spouses Protection Act uses all of that information.
So if we're just on the mathematical formula, which is the 143 divided by 288 times 5, where does former husband's rank come into that formula?
That's by the Uniform Services Former Spouses Protection Act.
Do you agree with me that I can divide 143 by 288 and multiply by 0.5 without knowing his rank?
Yes,
Then how do I read that language not being there? What else could it possibly mean?
could mean the second part based on that. But I'm sorry, I cut you off.
No.
Okay. Now, the one thing that I wanted to address his first, but the one thing that I wanted to start with is Florida Family Law Rules of Procedure 12.530 specifically states that if you want to object to something, you have a concern or anything like that, you must file a motion for rehearing. The appellant has stated that this is a single issue. There is not a requirement to file a motion for rehearing. No, because the rule specifically states that you must file it. As a matter of fact, in Newton v. Augustin, this court adopted the 4th District's Top Valpo. And Top Valpo, the specific case stated that if you go and you do not file a motion for rehearing for any error that appears on the face of the judgment, you will have waived it. In this case, the appellant wants to say, this is just like the Lawrence case. This is nothing like the Lawrence case. In the Lawrence case, where it might be similar that there appeared to be a single argument, in Lawrence, the appellant actually filed something, actually served something on the judge, actually told the judge, something's wrong here, you're not following the contract. Also, In the Lawrence case, that judge actually wrote the order and the judge put in its interpretation of what the contract meant, as opposed to simply saying, this is the contract. In the case herein, the appellant did not file anything because he felt that it wasn't necessary. This isn't a sufficiency of the evidence. He didn't make that argument in the initial brief, so therefore he went that.
Where do you get in 12.530, that a motion for rehearing had to be filed as it relates to a legal challenge that was the sole focus of trial?
No, it's, as far as the findings are concerned, the
It's
appellant,
reserved for appeal, a challenge to the failure of the trial court to make required findings of fact in the final judgment. A party must raise that issue in a motion for rehearing under this rule. I guess I just struggle to see where the trial court failed to make findings of fact.
61.0, he raised 61.075 and 61.076 as far as it being deficient. As a matter of fact, when he started off, he specific, as I read before, violates every rule of equitable distribution as far as pension division. And then in the brief, it brings up 61.75 and 61.076 and went in to explain how it should be divided.
Okay, I think I understand your argument. As it relates though to the contract, plain language being ambiguous or unambiguous or what it meant, you agree that that was raised fully before the trial court? I mean, you guys just had a whole trial about it, right?
Correct.
Okay. I just don't know how that would need to be raised in a motion for rehearing.
Any error, 6th District and Newton v. Augustin, any error on the face of the judgment must be raised in a motion for rehearing.
What if it was the whole thing that everybody talked about at trial? Isn't the point of a motion for rehearing to call the trial court's attention matters that it should have considered but didn't?
Yes,
So what didn't the trial court consider about the plain language of this contract that you guys had a trial over?
because if for some reason with what is being done right now and what was raised in the brief, stating that you should have used this, you should have used that, that should have been raised in a motion for rehearing. If you feel that the judge made an error or the judge did not follow the contract, the judge did not perceive a particular argument, that needs to be raised in a motion for rehearing. Otherwise, Newton v. Augustin has absolutely no meaning. And I think that Newton v. Augustin and Top Valco, they definitely do have meaning. So that's the reason why a motion for rehearing was absolutely required. Because even if you look at Top Valco, they went through and Top Valco said, those are very good arguments. As a matter of fact, we might agree with them. But you did not raise those arguments in a motion for rehearing. Since you did not raise the arguments in a motion for hearing, you waived them. And if Newton v. Augustin adopted that, well, the Top Valco is pretty clear as far as that's concerned. Let me go through, excuse me. Now, the appellant also stated they're not asking for a windfall. The demonstration of math would be that, yes, they are getting a windfall, and they would get a windfall if the, which,
So you acknowledge that if we were to accept your interpretation of the agreement, that's not how it works in the absence of an agreement, right?
oh, absolutely, right.
Yeah,
If there's not an agreement, you go directly pursuant to 61.075.
So in the absence of an agreement, she wouldn't be entitled to what you're asking for, right?
That's correct.
You
Right.
think it's there, but and you think it's the other side that's asking for a windfall?
Absolutely, because if they're going through and they're using the smaller percentage and applying it to the number that they want, yes, there is windfall, and that was demonstrated in the motion in limine, and that was also demonstrated in the answer brief, as far as the numbers are concerned. Because the share, if you decided that we're going to use the second part, that share would have been larger. Because as I stated, the appellee would take a 25.5% haircut. So that is, that would definitely be a windfall for them. I think my time is about expired, so what I have to do is request the court to the trial court. And I would have to rely on. Anything that wasn't.
Thank you.
Thank you.
Okay, please include. There are two reservations of jurisdiction, either of which would allow the court to do the math and calculate correctly the appropriate share of military retired pay. There is a reservation on the face of the final judgment. And there is a reservation within the specific language about the division of military retired pay. And that reservation, the court has probably read it, but it appears in the record on page 340. The court entering this final judgment shall retain jurisdiction to calculate, if necessary, the correct percentage of military retired pay to be paid to the wife, right? So that's the percentage that we focused on and agreed to. But using the formula set forth above and based upon the rank, which we all agree was E7 at all times, years of service, which we also agreed on, and retired pay base. That's where all the agreement fell apart. And to affirm the trial court's order would be to read out the words retired pay base. And if the court were to look at, I believe it was 28 USC 1408. In the record, we talked about and defined what the retired pay base was under the federal statutes. And that is the pay base that's used to calculate the military retired pay, as I indicated initially, which was 2013 using the high three. And all we're asking is take it to leave it at 2013 where it was supposed to be under the parties agreement on the final judgment, and don't take it forward to 2018 because he did retire under a high three analysis. So all we're asking is use the correct date and time and the correct retired pay base, which was the 3288. We're asking the court to remand with instructions to either adopt the 3288 outright, which I believe is the correct answer, but in any event to do what you're supposed to do when there's even a perceived inconsistency, which is to try to reconcile and give meaning to all of the terms of the final judgment. The Florida Supreme Court tells us that in Excelsior. And I believe the Fifth District, had a very similar opinion where it said the true meaning for the court to find and reach the party's intent is to construe the language, construe the party's agreement in such a manner as to give meaning to all of its terms and to harmonize those terms wherever possible. But the court's supplemental final judgment harmonized nothing. It did violence to the terms. Everything that had to do with, it got the percentage right, but everything percentage of what, it did violence to those terms. It eradicated them. It eviscerated them. They're gone. They're nowhere to be found. So I would ask the court to overturn that decision outright, as there was no contrary evidence and there is no contrary argument. If the court is to give meaning to using the correct retired base pay, the court has to instruct the lower court to adopt that number or determine that number again. But this court is in the same standing. This is under a de novo review. On a purely contractual basis, that reading, that order cannot stand. And none of the legal sorcery bases to uphold it, whether it be by a foregone affirmative defense or an admission against interest or parole evidence where there's lacking a clearly identified ambiguity, none of those can work. This is a straightforward calculation. The judgment did a pretty good job of it where it said, we're going to take this percentage, 24 point, I believe it was 83%, times the correct pay base. And that was E7 as of 2018. I'm sorry. The 18 and the 18 years are getting me caught up. E7 at 18 years, which was as of April 2013, using those pay numbers as though he had retired at that time. I don't have anything further.
Thank you. We'll be in recess.